Afternoon and welcome back to the Law&Crime Trial Network. I'm your host, Brian Buckmire, joined here with Jason Friedman. Again, we are still covering the Timothy Jones case that's currently in session, but we will be focusing on the Kellen Winslow Jr. case, that being the NFL case that we've been focusing on at this time. So that's testimony from Jane Doe number 1. Again, the charges that Kellen Winslow is facing are kidnapping for a specific felony crime, forcible rape, and forcible oral copulation as to this victim. And Jason, as we're listening to this, she's kind of laying it out pretty well as to all the steps that occurred.
Yeah, I think her recall, is pretty good. One of the problems with directing, the victim of a sex crime or a rape is going down that road and getting to be able to recreate things so vividly. It's a really, really traumatic experience, and you can't have it both ways. On the one hand, if they remember every detail exact, they try to use that against a defendant, saying, with all this trauma going on, how can you be so sure of all these details? Of course, if they leave out a few details, they try to throw that back into the victim's face as well. I thought she was pretty credible, and it almost seemed like she was thinking in her own head and visualizing what was going on, so then she can accurately describe it in response to the direct examination questions from the prosecutor.
And then I know we didn't see it in this segment, but as to the alleged victim, we did hear on cross-examination that there was some inconsistencies that she did make in the preliminary hearings that she did on direct. How is that going to go to weighing, I guess, both to this individual alleged victim, but also to the tenor of the rest of the case?
Sure. I mean, inconsistencies are never a good thing as a prosecutor. You want everything to line up, nice. The reality is it doesn't always happen that way. Inconsistency is very common. I would try to characterize this as a pretty, not a significant inconsistency. However, to answer your question better, if it was just this victim that he was being accused of raping, I'd be a little more concerned as a prosecutor. About the overall case, because of the number of victims, because not every charge is the same, I don't think on the overall case, considering all 5 victims, it's going to have much or any impact at all.
Yeah, and as we're continuing through it and she's giving her actually, I'll ask this as a former prosecutor, because I know that often prosecutors will attempt to lessen the blow for people's memories, because as we all know as humans, our memories are not that great. Like, I don't know what I ate for breakfast this morning or the morning before that. So how do you, as a former prosecutor, kind of lessen the blow when your alleged victim is about to take the stand and give a recount and there might be inconsistencies? Is there a way to try to prepare the jury for that, to try to make it a smoother transition?
I usually bring that home, and my personal experience is I usually try to bring that home in closing arguments. When I talk about that, and kind of what you said, I didn't know what I had for breakfast this morning, I kind of just talk to the jury and say, all of us remember things differently. There were things that happened 10 years ago that are seared into my memory. I remember it like it's yesterday. And there were things that I did yesterday or the day before that I can't remember. And all of us remember things differently. And just because she can't remember every single detail, or because there was an inconsistency or two, don't hold that against the members of the jury. Because remember what she said. She testified as to the rape. She was very credible. And because there was a couple of little things she didn't remember or an inconsistency or two, not really a big deal.
Yeah. And as we said, there are 5 alleged victims in this case. So let's move now from Jane Doe number 1 to Jane Doe number 2. So just as a recap, this is Jane Doe number 2. And for this alleged victim, the defendant is charged with forcible rape and sodomy by use of force. Now, at the time she was homeless. Now I believe she's living with her mother. I know, Jason, we were talking before the break about the use of the word victim, how we thought it was odd that the judge allowed them to say victim, because often, actually, I'll let you explain it, because you had a great way of explaining it.
Right. So normally, you're not convicted as a criminal defendant. Mr. Winslow is not convicted. He's being charged. You're presumed innocent until found guilty. So the victims are normally referred to as alleged victims, because right now it is still an allegation. My understanding is there was some motion practice about this, and the judge, which I think was unusual, granted an application to actually refer to these women as victims. The concern as a defense attorney I have is that, by referring to them as victims, you're sort of saying it's a foregone conclusion that the defendant is then guilty. Yeah. Right now, until you're found guilty, it's all allegations, right? Yeah, and the problem is that the jury hearing it over and over and over again, there's going to be, if not conscious, some sort of subconscious effects on them. And as they're listening to Jane Doe number 2, I know we can't see her, but obviously the jurors can see her, and we can see her hands. Looks like she's fidgeting and very nervous.
I hear a very sympathetic witness on the stand. I'm not sure how you hear it as well.
I totally agree with you, Brian, on that. You could almost, she had a much more, I don't want to say feeling about her testimony, but you could feel her a little more, I think, as compared to Jane Doe number 1 that we just heard in the prior segment. I think she was very credible in the way she was expressing herself. She comes off, she was in her 50s when this happened, homeless or living in a shelter. She probably had a hard life up until that point. That's probably one of the reasons why, if he did do this, he was preying on, women like that.
Yeah, and we also discussed while we were on with Aaron Keller about how all these cases are lumped together, and he made a great point that, and I think you echoed it as well. If it was just one, maybe if it was just two, we might be able to find innocent and not guilty beyond a reasonable doubt. But now that it's compiled like this, it almost makes it like he's a predator. He preys on the elderly and the homeless and the transient, and that's his MO. I think that's why they probably put together.
I agree with you, Brian, because by having multiple alleged victims at the same time, you are buttressing the overall case. So even if there's some holes potentially in any one particular case, taking all 5 together in the overall testimony of all 5, you almost have like a snowball effect. And so at the end of it, you have a very big pile of evidence against the defendant.
Yeah. And as that snowball grows, we're going to actually go to break and come back to listen about the testimony from Jane Doe number 3. So again, just to remind you, based on the laws, we're not allowed to videotape the alleged victims because of the nature of the case. We don't want to expose their faces, and that's probably a decision from the judge. But Jason, as Jane Doe number 3 is talking, this again kind of feeds into our story of misidentification. For her, it's partly, and somewhat understandable, I think Moni would agree, that she saw something she didn't like and she just averted her face. She's not looking at this man's genitalia and saying, let me look at his face, let me make sure I get a look. She's saying no. So, I mean, I see good and bad for both sides.
I agree with you. Not only the genitalia, she explicitly says, I didn't even look at his face. I just saw that, I turned, I don't know anything. She was pretty clear, obviously, on the tattoos, and that's the identifying factor that Mr. Winslow has, the tattoos. And that's the best thing she can do. So this is not really a misidentification situation. She can only testify to what she remembers and what she saw, and it's up for the prosecution, obviously, at that point, to put 2 and 2 together.
Yeah, and I'm not sure, but I think, at least for me, without, I mean, maybe I'm just biased because I have tattoos as well, but without some specificity as to those tattoos, I saw 2 hands with roses, I saw a woman's face, I saw a baby's face, I saw the words, baby girl or whatever it is. I mean, how many biracial men are in this area with sleeve tattoos?
I was thinking the same thing, because she was not able to specify anything in particular, whether a color, a shape, a word, as you say, an image, something that the prosecution can point to and say, aha, here's a picture of his arm, and that's the exact, word, letter, image that this alleged victim testified about.
Because I'm not sure how many cases you've had that have decided on tattoos or markings or even scars, but oftentimes when that's used, it's very descriptive. He had a scar from ear to ear. He had a neck tattoo of a lipstick kiss or a spider or something like that. And that specificity is almost damning, where you're sitting there with your client looking at his neck or her neck and be like, oh, it's not going to go well.
Yeah.
But I didn't hear that.
I didn't hear that, and I think if she was the only complaining witness in this case, there probably wouldn't be a trial.
Yeah. And let's actually listen more to her testimony as how she described the assailant and the identification. So as I'm listening, as I was talking about the identification with Jason, we actually did take a look at the photo of his arm. And Jason and I, as we look at it, to me, at least, it looks like some sort of tribal tattoo. I can see the streaks and the marks on it, and I do see the University of Miami with the blue and the orange. And so I remember she did talk about a color blue and some stripes, but I guess this is the defense attorney inside of me that's saying that's not enough. That's still pretty vague.
It's still pretty thin. I don't know if we're going to be get to it on cross-examination, but what was the physical distance between them at that time? And how good of a look, did she get? She is credible because she's not trying to say, oh, I saw his face, I can ID him, because that's obviously going to fall apart. She's sticking to what she knows, and that is that tattoo. But there's still plenty of room, I think, as a defense attorney to cross-examine her on that ID. It's pretty thin, just based upon what I know so far.
Yeah, but I'll be devil's advocate that I actually appreciate the vagueness to some degree, because I know if she had said, there's this tattoo and the University of Miami is on the upper this side with the detail, I think everyone, at least a defense attorney, would have been there like, she's seen the photo.
That's right.
She was prepped. Someone showed her the photo. If her vision is this vague, she would not have the specificity to that degree. So again, this might become a case, well, if there's less alleged victims, it might be the case as to who could best argue some of these arguments, because there's arguments on both sides.
Yeah, and especially for this particular complaining witness. I agree with you, Brian.
Yeah. So as she recounts what happened, how are we to pull apart the mis-ID here? Is this vague enough to be true or too vague to know the person?
Right. Obviously, as the prosecutor, I'm saying there's no mis-ID. The ID is very, very solid. She's testifying about what she saw that day. I imagine a picture of his tattoos will be made to show that in open court. She might even be asked, do you recognize those? Do those look like the tattoos that you saw on that day? And she's going to respond, accordingly. So if I'm the prosecution, I'm just staying firm, and I'm talking about different ways to ID.
And we'll find out more after this break.